Mr. Draskovich, let's go to Bobby Smith. Let's go to page 22, C-372-769, State of Nevada versus Bobby Smith. May the record reflect Mr. Smith is present at liberty. Mr. Draskovich is here on his behalf. Ms. Luzaich is here on behalf of the state. All right, this is on for the defendant's petition. I have read the petition, I have read the return, and I've also read the reply, but I'm gonna tell you guys what's gonna happen today is I'm gonna let you guys argue this, and then I'm gonna issue a written decision because I wanna read the grand jury transcripts in their entirety. Okay?
Absolutely.
All right, Mr. Draskovich, anything you want to add to your moving papers?
Just briefly, I know Your Honor reads everything, and you really do need to look at the transcripts. I mean, obviously, the legal standard is under conditions that the defendant knew or should have known. I mean, there has to be an outward manifestation. I mean, the statute doesn't require clairvoyance on his part. And while the circumstances may be less than tasteful, the court may not like lifestyle choices, nonetheless, it shouldn't be illegal. And what the state's doing here is, for all three, I mean, counts 1 through 5 for one alleged victim, count 6 through 9 for another, and count 10, they expect the defendant and or defendants to, number one, assuming they occurred, to understand these internal conflicts that these alleged victims may have had when there was no objection voiced. In reference to the sex story counts, counts 6 through 9, there's ambivalence, and we're taking the truth, the testimony, but we're truthful. If there's ambivalence initially and then later there's use of sex story, that doesn't make it non-consensual. I would submit that the state has not met its burden on all 10 counts, and I would submit that given the appropriate legal standard, the objective legal standard, and your careful review of the transcripts, this gentleman should not be held to answer any of the counts currently pending. I'm not submitted.
Ms. Luzaich?
Just briefly, Judge. First of all, it's against their will or under conditions in which the defendant knew or should have known that they could not consent. And all three women testified very clearly that what was happening, they didn't want to happen. All of the case law that is cited about whether he knew or should have known or reasonable consent, those are all trial issues. At this point, it's only slight or marginal evidence. And in the very last sentence of their reply, traverse, call it what you will, they state that under Nevada law, which requires either force or facts to show the defendant rendered the alleged victim unable to consent or didn't consent. That is not accurate. In fact, the Nevada Supreme Court has said on numerous occasions, and I cite specifically from McNair again, physical force is not a necessary element in the commission of the crime of rape or sexual assault. Force is nothing in this situation. He portrays himself, he's the pastor, he's the godfather. That is like the prime position to be, the goddaughter to the person who runs the church. He's grooming these girls to go along with his wants and needs. And at this point, for purposes of grand jury, the fact that they all testified that they did not want these things to happen is sufficient. Obviously, at trial, my burden is different, and I do have to show that there was not a reasonable, if mistaken, belief in consent. But I do not have to show that at this stage of the game.
In response, briefly, when it's under conditions that a defendant knew or should have known, that generally is if there's an intoxicant administered, if the person is passed out, not able to consent. We really don't have that in this case. So what the state would have the court do is basically incorporate an element of status to then infer that there is a not consent or that there was an objection made. And I'd submit that that's dangerous territory.
All right.
And just so that we're clear, I'm going under the against their will, not under conditions.
Okay. All right, and like I said, I want to read the grand jury transcripts in their entirety, so I'm going to read them in their entirety, and I will issue a written decision regarding this.
Thank you very much.
Okay? Thank you. All right, thank you, guys.
There is one other matter that Ms. Luzaich just brought up before this matter being called concerning the trial date.
Okay.
We have no objection to a continuance. I believe the state, it can be a joint continuance, obviously, depending upon the court's decision. that
Depending
may
on
not-
the court's decision, because if the writ is granted, there won't be a trial date. So we can address that depending on what the court's decision is if necessary.
Okay,
Okay.
but I just want to let the court know, obviously, we won't have a trial setting, but if we do, I anticipate having it moved.
Okay.
And the state brought it up, I mean, it'll be agreement by the parties.
I have an invoke that's definitely going on the 3rd.
Okay. All right.
Thank you very much.
Okay.
And
Thank
I'm
you.
sorry, did you say you're just gonna issue it, or is there a?
No, I'm
date?
just going to issue a written decision because
Okay,
right
so
now we
the-
have dates, so the case won't get lost.
Calendar call stands.
Yeah.
Thank you.
Dates are standard.
Thank you.
Okay.
Where's that?
Thank you.